So, very good evening, all the participants. Today, let us try to cover part 4 and part 5. So, we will be covering part 4 and part 5 through charts because the coverage is more, but the marks awarded are less. In part 4 and part 5, no case studies will be coming. Case study will come from this professional ethics, part of which we have already covered, that will be covering separately. But other than professional ethics, out of part 4 and part 5, you can expect questions from I think 3 to 4 marks. But the coverage is more than 500 slides, right? If you see the material, lot of regulations are there. So naturally, we can do some sort of selective reading in part 4 and part 5. Now I would request Kajal Kiran ji to please read all these regulations. Kajal Kiran ji, आप पढ़िए जरा एक बारी.
सॉरी सर, अभी ना मेरे घर में ना बहुत सारे इलेक्ट्रिशियंस आ रखे हैं, तो बहुत आवाज होगा इस साइड से.
Okay, no issues, no issues. I'll be reading it. ठीक है. हाँ. So the first thing is that what you have to do to become an insolvency professional. First of all, you have to clear the limited insolvency examination within 12 months from the date of application for registration with the board. Now, as per latest amended regulations, it is 24 months. It is 2 years now. But as per our syllabus, you have to apply within 12 months from the date of passing of this limited insolvency examination. And there is a consolidated form for application to the IPA and the board. In Form A, you have to apply with a non-refundable fees of 20,000. So that is basically the registration fees. That is the processing fees, you can say. And board shall grant the registration in Form B within 60 days of the receipt of the application. Now, suppose the board has some objection, then what will happen? If the board has objection, then they will revert actually. So board may just a minute. So first of all, if they have any objection, then board will communicate about the application rejection within 45 days of the receipt of objection. So they will say that why your registration should not be rejected. And then the IP has to revert within 15 days of the communication, and then board will revert about the final decision within 30 days of the receipt of explanation. This is equally applicable both in case of IP and IPA. And now once registration is granted in Form B, then you have to pay board fees of 20,000 every 5 years on or before 30th of April. In case you are not able to pay, then simple interest at the rate of 12% is applicable. Besides this, you have to pay to the board a fee is calculated at the rate of 1% of the professional fees earned in just a month. In Form E, for the preceding financial year on or before 30th April, you have to keep records for minimum 3 years, and you cannot, if you are not a citizen of India, then you cannot render services as an IP unless you are a partner or director of an IPE. So even if you are not a citizen of India, even if you are not a resident, then also if you have passed the examination, there is no bar in appearing for the examination, but you cannot render services as an IPE unless you become a partner or director of an IPE. Another important point is regarding this authorization for assignment. This authorization for assignment is similar to certificate of practice. So this amendment was made in December 2019, and they said that you cannot take an assignment after 31st December 2019 unless you hold a valid authorization for assignment. Now refusal to grant the certificate. So board may reject and give an opportunity to be heard, and IP needs to revert within 15 days of such communication. And then within another 30 days, the board will either grant or reject the certificate of registration. There is a provision for temporary surrender also as per regulation 10, and it says that IPA will inform the board whenever it issues an AFA, whenever it renews an AFA, whenever it suspends or cancels AFA, and whenever it revokes the suspension of AFA, except surrender of AFA within 1 working day of taking such action. So basically, as I told you, there are two things. One is the IPA, which is the monitoring agency, and then the board. So IP is under regulation by both IPA as well as board. So IPA is like a college and IBBI is like a university. You are being regulated by both. So whenever you apply for an AFA, you apply to the IPA. And whenever there is a change, issue, renewal, suspension, cancellation, revocation of suspension, surrender. So within 1 working day of taking of such action, IPA shall inform the board. Now, regarding the show cause notice. So show cause notice to be served at IP address provided by him or IPA through registered post with acknowledgement, or through electronic means at the email address provided by the IPA to the board. And board will constitute the disciplinary committee to dispose of the show cause notice. Disciplinary committee shall dispose of the show cause notice within 6 months of its receipt, and order shall not become effective until 30 days have elapsed from the date of issue of such order by disciplinary committee. This period of 30 days is given so that the person affected can file an appeal. An order to be issued to IPA immediately and published on the website of the board and to IPA immediately. Note: full-time director not required here, unlike in IPE and IPA. Then, if you are an IPA, and so just like an IP is applying to the board, similarly IPA, IU, they are also applying for registration to the board, and board will acknowledge the application within 7 days. Now, what are the eligibility requirements for an IPA to be registered with the board? If you are an insolvency professional agency, as we know, there are only 3 insolvency professional agencies. So what are the basic requirements? These are given in regulation 3(1) of the IPA regulations. First of all, it should be a company which should be registered under section 8. It should be a section 8 company. Second is that its sole purpose should be to carry out the functions of IPA. Third is it has its bylaws and governance structure as per the board. So there are model bylaws and governance structure which has been specified by the board as per model bylaws. So this IPA has to frame its bylaws and governance structure as per the board model bylaws, right? Next is minimum net worth of IPA should be 10 crores and paid up capital should not be less than 5 crores. Another requirement is that it should not be under control of person resident outside India, and not more than 49% of its share capital should be held directly or indirectly by persons resident outside India. It should not be a subsidiary of a corporate body through more than one layer. So layering is not allowed, so that we can come to know of the persons who are behind the IPA. And the applicant, promoters, directors and shareholders are fit and proper persons. So these are the requirements. And what is fit and proper? So fit and proper means that including but not limited to integrity, reputation, character, absence of conviction and restraint. There should not be any restraint order, and then competence including financial solvency and net worth. Now, regarding shareholding by IPA, there are restrictions. So, no person, jointly or individually, directly or indirectly, can hold more than 5% of the paid up share capital of IPA. Falling can hold up to 15%. So, 15% is allowed for stock exchanges, depositories, banking companies, insurance companies, public financial institutions, multilateral financial institutions, and if you are a central government, state government, or statutory regulator, then you can hold up to 100%. अच्छा. Next is governing board. Regarding governing board, so governing board, in the governing board, more than 50% of the directors shall be independent directors. And whenever you want to hold any meeting, so at least one independent director should be present. And that independent director shall be the chairperson of the board. More than half shall be persons resident in India in the governing board, and not more than 1/4 of the total governing board members shall be IPs. Regarding application for registration or renewal of IPA, if you are a Section 8 company, then you are eligible to apply. You can make an application in Form A along with a non-refundable fees of 10 lakhs. For renewal, it is 5 lakhs along with Form A, and you need to submit last 3 years audited financial statements as well of applicant, promoter company, company who is in control of applicant, and company holding more than 10% of the share capital. And then you need to apply for renewal 6 months before the expiry of registration. Application to board in Form A with a non-refundable fees. IPA. And if the board is satisfied that the IPA is fulfilling all the requirements, it will grant certificate of registration or renewal in Form B. It should be eligible under Regulation 3. It should have adequate infrastructure, and it has in its employment persons having professional knowledge and experience, and is complied with Regulation 4. So these are the requirements for registration by IPA. Now, if the board wants to refuse registration of IP or IPA, it will communicate within 45 days of the receipt of the application, and the IPA or the IP will address within 15 days of receipt of such communication, and then board needs to revert about final decision within 30 days of receipt of explanation from IP or IPA. Surrender of registration. If an IP wants to surrender its registration, it will surrender its registration to the IPA, and IPA will inform the board within 1 working day. If an IPA wants to surrender the registration, then board shall publish the surrender notice by IPA on its website within 7 days, and it shall invite objections. Any objections are to be submitted within 14 days of such publication, and board needs to approve application by IPA within 30 days of receipt of objections. And then board shall publish on its website that the registration has been surrendered for the said IPA. Disciplinary proceedings against IPA. So show cause notice is to be served at the IPA registered office through registered post with acknowledgement, or at the email address provided by the IPA to the board, and board will constitute the disciplinary committee to dispose of the show cause notice. Disciplinary committee shall dispose of the show cause notice within 6 months of its receipt, and order shall not become effective until 30 days have elapsed from the date of issue of such order by disciplinary committee. An order to be issued to IPA immediately and published on the website of the board, and only full-time member of the board can pass this order. Now regarding appeal. So if the registration is cancelled, if the registration is refused, then IPA can appeal within 30 days of the receipt of such order to NCLAT. So the appropriate forum for appeal is NCLAT. And if the registration of an IP is refused, नरेंद्र जी, अगर आईपी का
सर
रजिस्ट्रेशन रिफ्यूज होता है तो कहाँ अप्लाई करना है?
आईपीए सर।
हम्म
सेंट्रल गवर्नमेंट।
नहीं 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 नहीं, आईपी का रजिस्ट्रेशन।
नहीं, अपील टू अपील इफ
बोर्ड ने रिफ्यूज कर दिया
बोर्ड
आईपी का
बोर्ड
रजिस्ट्रेशन, बोर्ड ने रिफ्यूज कर दिया
हाँ
भाई। अल्टीमेटली आईपीए के पास क्या होता है? एनरोलमेंट होता है, रजिस्ट्रेशन होता है बोर्ड के पास। बोर्ड को अप्लाई
हाँ
किया, बोर्ड ने रिफ्यूज कर
रिजेक्ट
दिया। नॉर्मली तो हाई कोर्ट पे, कोर्ट में जाते हैं, लेकिन क्या प्रोसीजर क्या है? एनी आइडिया?
नो सर।
नहीं।
No such procedure is mentioned,
हाँ
sir. I think procedure is not available in our syllabus. It will be direct. We can go for appeal.
नहीं, अपील जाओगे कहाँ? जैसे आईपीए का तो लिख दिया, आईपीए का लिख दिया, एनसीएलटी में जाओ। लेकिन आईपी के बारे में क्या है? लोग नॉर्मली हाई कोर्ट में जाते हैं।
सर हाई कोर्ट में ही होगा, हाई कोर्ट में ही होगा।
हाँ एनसीएलटी, एनसीएलटी बोलता है। सेक्शन 202 देखते हैं एक बार। सेक्शन 202 बोलता है, एनी इंसॉल्वेंसी प्रोफेशनल एजेंसी which is aggrieved by the order of the board under section 201 may prefer an appeal to NCLAT। बट ये आंसर तो नहीं हुआ ना।
You are asking about IP, right? Not IPA.
IP, yes, insolvency professional। Normally people approach high court for this।
सर एनसीएलटी में तो सिर्फ कंपनी जाएगी ना सर, इंडिविजुअल कैसे जा सकता है आईपीए तो? एनसीएलटी एनक्लेक्ट में सर।
हम्म चलिए कोई बात नहीं, देख लेंगे इसको क्या है इसको, कि वेयर शुड वी अप्लाई इन केस ऑफ रिफ्यूजल ऑफ रजिस्ट्रेशन बाय IBPI। Then for IPA, there is a provision for grant of in principle approval. So if an IPA wants to apply for in principle approval, they can also apply with non-refundable fees of 10 lakhs. And if the board is satisfied that the applicant is fit and proper, proposed company may meet all requirements, so they may grant for, the in principle approval for a period of 1 year. Next point is regarding amendment in bylaws. So if an IPA wants to amend its bylaws, then it can amend with 75% of the approval of the governing body. Resolution has to be filed with the board within 7 days of its approval. Amendment shall come into effect on 7th day of the receipt of approval. and then they need to file the amended bylaws in printed form to the board within 15 days from the effective date. So they can amend the bylaws with 3 times vote in favor, as and against means 3/4 majority means 75%. So basically these are some of the things regarding registration. Similarly, there are some provisions regarding this IU also. Okay, if you are an IU, then what are the provisions? So it says that no person can function as IU without certificate of registration by the board. So IP, IPA, IU all have to obtain registration from the board. And then its bylaws should also be in consistency with the board bylaws. An IPA has to be a Section 8 company, but an IU has to be a public company. And its sole purpose should be to provide support services under the regulations. Minimum net worth requirement in case of IU is 50 crores. It should not be under the control of person resident outside India. Not more than 49% of its share capital or voting power should be held directly or indirectly by persons resident outside India. Applicant, promoters, directors, shareholders are fit and proper person. And this fit and proper is including but not limited to integrity, reputation, character, absence of conviction, and state order, and competence including financial solvency and net worth. Then there are restrictions on holding. So no person of an IU can hold jointly or individually, directly or indirectly, hold more than 10% of the paid up capital or voting power of the IU. Following can hold up to 25%. Government company, stock exchange, depository, bank, insurance company, public financial institutions. And if you are a state government, central government or statutory regulator, then you can hold up to 100%. Governing board in case of IU, more than 50% of the directors shall be independent directors. Minimum 1 independent director is required to do the meeting. Independent director shall be the chairperson of the board, and application for registration has to be made to the board in Form A with a non-refundable fees of 10 lakhs. And this is the fees for registration as well as in case of renewal. And then every IU has to pay annual fees at the rate of 10% of the turnover. The board shall grant the registration within 60 days of the application in Form B. And then the IU has to pay the registration or renewal fees of 1 crore within 15 days of the issue of certificate of registration or renewal. This certificate is valid for 5 years from the date of issue, and if there is any delay in payment of fees, then simple interest at the rate of 12% per annum is chargeable. If the board wants to reject the application, then it has to communicate to the IU within 45 days of the receipt of application. IU shall address its reply within 15 days of the receipt of such communication, and then board needs to revert about final decision within 30 days of the receipt of explanation from IU. If the registration is expiring, then the IU needs to apply for renewal 6 months before the expiry of registration. There is a requirement to seek prior approval of the board if a person wants to hold more than 5% of the share capital, if there is a change in control, mergers and acquisitions, sale or disposal of whole or major part of its undertaking, voluntary liquidation or discontinuance of business by an IU. Similarly, it has to intimate to the board if any person holding more than 5% of the share capital or voting power ceases to hold such share capital or voting power within 15 days of such cessation. There is a requirement for this. There is a provision for in principle approval here also. And if the board is satisfied that the applicant is fit and proper, then proposed company may meet all requirements. It may grant for a period of 1 year. Regarding amendment of bylaws by IU, similar procedure as in case of IPA. Bilkul same hai. So IU can also amend the bylaws with 75% of the approval of the governing body. A resolution has to be filed with the board within 7 days of its approval, and amendment shall come into effect on 7th day of the receipt of approval. Then you need to file amended bylaws in printed form to the board within 15 days from the effective date. ये कुछ प्रोविजंस हैं रिगार्डिंग आईपी, आईपीए एंड आईयू. इन्हीं में से कई बार सवाल पूछ लेता है. जैसे आईयू है, आईयू में पूछ लेता है कि नेटवर्थ कितनी होनी चाहिए, कैपिटल कितनी होनी चाहिए, ये सब पूछ लेता है सवाल कई बार. या रजिस्ट्रेशन फीस के बारे में भी पूछ लेता है. तो इतना तो कम से कम आपको ध्यान में होना चाहिए. मिनिमम नेटवर्थ पे सवाल पूछ लेगा कई बार. या इंटरेस्ट पर सवाल पूछ लेता है कि इंटरेस्ट कितना होगा इन केस ऑफ लेट पेमेंट, सिंपल इंटरेस्ट होगा, कंपाउंड इंटरेस्ट होगा, ये सब बात. Now, if there is a concept of an IPE also. IPE का क्या कॉन्सेप्ट है ये भी थोड़ा सा देख लेते हैं. IPE के बारे में ये है कि you can practice as an individual as well as an IPE, insolvency professional entity. So if you want to practice as an IPE, then you have to be a company or a registered partnership firm or LLP. So any company, a registered partnership firm or LLP with minimum net worth of 1 crore. So minimum net worth requirement here is 1 crore, and majority of the directors, partners, shareholders, whole-time directors should be IPs, and they should not be a partner or director in any other IPE. Okay. Then you have to make an application in Form C with 50,000 fees, and board may grant the registration in Form D. And you have to inform the board within 15 days if there is any change. Any delay in payment of fees for IP or IPE, simple interest at the rate of 12%, board can de-recognize by a reasoned order. Earlier there was a concept of recognition of IPEs, but now there is a provision for registration of IPEs. Then you need to submit the copy of the financial statement as on the date of net worth certificate along with Form C. These are the various forms which are required to be submitted. Application for registration as an insolvency professional, Form A. And if you are an IPE, then you have to submit Form AA. Okay. Certificate of registration of an IPE or IPE will be given in Form B. Application for recognition as an insolvency professional entity, Form C. Insolvency and Bankruptcy Board of India Certificate of Registration, Recognition in Form D. Annual Statement of Professional Fees in Form E. Information of cessation or joining as a director or partner in an IPE is to be given in Form F. Then Form G is for Annual Statement of Turnover of the IPE. And Form H is Compliance Certificate. Now let us see the provisions regarding inspection and investigation and what is the difference between the two. So section 217 and 218 cover these things. So section 217 says that inspection can be done on the basis of a complaint received, or it can be done suo motu also, right? The purpose of inspection is to ensure compliance of the code and regulations. And section 217, if we see, so section 217 says any person aggrieved by the functioning of an insolvency professional agency or insolvency professional or an information utility may file a complaint to the board in such form within such time and in such manner as may be specified. And 218 talks of investigation of insolvency professional agency or its member or information utility. This inspection is conducted by inspecting authority. Confidentiality, of course, has to be maintained. Normally, before starting inspection, the IBBI will give 10 days notice, but that notice may be dispensed with if the authority feels that the person may tamper the documents. So in that case, that requirement of 10 days may be dispensed with. There is a provision for interim report to the board. If board requires, it may ask for the interim report for the inspection. Then draft report is prepared. Copy of the same is provided both to the service provider as well as the board. Okay. Inspection will be done by the inspecting authority, right? And inspecting authority will provide a copy of the draft report both to the service provider and the board. And final report is issued by the inspecting authority after comments from service provider and the board. And what is the effect of inspection? The effect of inspection is that the matter may be referred to disciplinary committee on interim report or investigation. Regarding records, it has the power to examine the records. Now let us see the provisions regarding investigation. Normally, investigation is preceded by inspection, although it may not be necessary. Direct investigation may also be started. The purpose is to inquire into complaint received. The investigation is conducted by investigating authority. Confidentiality, of course, has to be maintained. Normally, they will give 10 days notice, but that may be dispensed with reasons to be recorded in writing. Regarding interim report, it is to be given by the investigating authority on request of the board. The draft report, in case of investigation, a copy of the draft report will not be shared with the service provider, but only with the board. In case of inspection, it is shared with both the service provider and the board. And final report, in case of investigation, shall be issued after advice from the board. And what is the effect of investigation? Show cause notice under section 220 or 236(2), the matter may be referred to disciplinary committee. Regarding records also, in case of investigation, powers are more in case of investigation. So the investigating authority may take custody of records and they may keep the records with them for a period of 6 months. Or they can also seize the record with the approval of the court, and they can take assistance of police in case of any resistance. So this is the brief regarding inspection and investigation. Now let us see some of the provisions regarding grievance. And what is the difference between grievance and complaint? So grievance is basically when there is a suffering by a stakeholder, and complaint could be contravention of law and you need not prove any suffering, right? So the cause of action in case of grievance is suffering by the stakeholder, and in case of complaint it can be contravention of law. In case of grievance, no fees is payable, but in case of complaint, 2,500 rupees fees is payable. In case of grievance, no form is required, but in case of complaint, form A is required. Timelines: within 45 days of the cause of action, grievance has to be settled. No, grievance has to be filed actually. So grievance has to be filed within 45 days of the cause of action, and delay up to 30 days can be condoned in case of sufficient reasons are there that okay, this grievance or complaint could not be filed. Mode of filing could be online or by post or by hand. In both the cases, disposal shall be done of such grievance or complaint within 30 days of the receipt. And whether complainant's request to review board's decision, this is applicable in case of complaint. So within 30 days of the disposal, complainant can request the board to review its decision, and board shall dispose of the review within 30 days of the request for review. Effect in case of grievance shall be that the service provider may be directed to redress the grievances. And in case of complaint, the authorities may order inspection or investigation or issue a show cause notice. Even these fees can be refunded if the complaint, if there is found to be substance in the complaint. Another important thing to remember here is that you cannot file an anonymous complaint. So you have to disclose, but you may request that, okay, my identity may not be disclosed, but it is up to the authorities. It is up to the IBBA. हो गए। अच्छा, अभी हम क्या करते हैं, अपना दोबारा उसी पीपीटी पर चलते हैं, वहां से कुछ देख लेते हैं प्रोविजंस। अपडेट न्यू बेयर कोड। बोर्ड पर चलते हैं, 529 स्लाइड नंबर 529। वेल, तो सेक्शन 188, ये स्क्रीन नजर आ रही मेरी? नहीं, माय स्क्रीन इज विजिबल? सेक्शन 188?
हाँ, विजिबल सर।
ओके ओके। तो सेक्शन 188 क्या बोलता है? ये बोलता है कि देयर शैल बी एस्टैब्लिश्ड ए बोर्ड बाय द नेम ऑफ इंसॉल्वेंसी एंड बैंक्रप्सी बोर्ड ऑफ इंडिया। बॉडी कॉर्पोरेट है, having perpetual succession and a common seal with power subject to the provisions of this code to acquire, hold and dispose of property, both movable and immovable, and to contract and shall by the said name sue or be sued. हेड ऑफिस होगा एनसीआर में, ठीक है। कॉन्स्टिट्यूशन ऑफ द बोर्ड, कॉन्स्टिट्यूशन ऑफ द बोर्ड में क्या होगा? द बोर्ड शैल कंसिस्ट ऑफ द फॉलोइंग मेंबर्स हु शैल बी अपॉइंटेड बाय द सेंट्रल गवर्नमेंट। एक होगा चेयरपर्सन, देन 3 members from amongst the officers of the central government not below the rank of joint secretary or equivalent, 1 each to represent the Ministry of Finance, Ministry of Corporate Affairs and Ministry of Law ex officio, ठीक है। तो एक चेयरपर्सन हो गया, 3 members हो गए इसके ex officio। उसके बाद हो गया 1 member to be nominated by RBI ex officio, then 5 other members to be nominated by the central government, of whom at least 3 shall be whole-time members. The chairperson and other members shall be persons of ability, integrity and standing who have shown capacity in dealing with problems relating to insolvency or bankruptcy and have special knowledge and experience. ठीक है। Appointment of chairperson and other members of the board, other than the appointment of an ex officio member, shall be made after obtaining the recommendation of a selection committee. Selection committee में क्या होगा? कैबिनेट सेक्रेटरी उसका चेयरपर्सन होगा, secretary to the government of India to be nominated by the central government member, and chairperson of IBBI in case of selection of member of the board, member होगा इसका, and then 3 experts of repute from the field of finance, law, management, insolvency and related subjects to be nominated by the central government as members. ठीक है। Term of office of chairperson and members other than ex officio shall be 5 years or till they attain the age of 65 years, whichever is earlier, and they shall be eligible for reappointment. और जो salaries, allowances payable to and other terms and conditions of service of the chairperson and members other than the ex officio members shall be as may be prescribed. तो इसके लिए सैलरी के रेगुलेशंस है, तो सैलरी रेगुलेशंस एक बार देख लेते हैं। सैलरी रेगुलेशंस क्या है? ये सैलरी के रेगुलेशंस। जो मेन चीज आपको देखनी है वो यहां पर देखनी है पे और अलाउंसेस। पे देख लीजिए, मेन पे के बारे में पूछ लेता हूं। पे आपकी चेयरपर्सन की है 5,62,500 पर मंथ, ठीक है, या पे एडमिसिबल टू ए सेक्रेटरी टू द गवर्नमेंट ऑफ इंडिया। और होल टाइम मेंबर की जो ऑप्शन है, ही कैन रिसीव पे एज एडमिसिबल टू एडिशनल सेक्रेटरी और ए कंसोलिडेटेड सैलरी ऑफ 5 लाख पर मंथ। इतना तो कम से कम याद आपको रखना है, ठीक है। अगर और कुछ नहीं भी पढ़ोगे इसमें तो कम से कम ये दो फिगर्स जरूर याद रख लीजिएगा, 5,62,500 और 5 लाख। फुल टाइम मेंबर का 5 लाख और चेयरपर्सन का 5,62,500। एंटरटेनमेंट अलाउंस है 6,000 पर मंथ, ये भी याद होना चाहिए, ठीक है। बोनस, नो एंटाइटलमेंट। चेयरपर्सन एंड होल टाइम मेंबर शैल नॉट बी एंटाइटल्ड टू एनी बोनस, ठीक है। सिटिंग फीस भी नहीं मिलेगा क्योंकि सैलरी मिल रही है ना इनको। तो इतना तो कम से कम आप ध्यान में रख लीजिए। चलिए दोबारा चलते हैं। 529
190 सर, रिमूवल ऑफ मेंबर फ्रॉम ऑफिस। नहीं लगेगा सर, पूरा हो जाएगा।
क्या
सेक्शन ही कितने हैं सर? 245 सेक्शन है सर, उसमें से पिछले के 10 तो करने नहीं है। पावर्स है 238 वाला हो गया, 238 वाला भी हो गया सर। 190 रिमूवल ऑफ मेंबर फ्रॉम ऑफिस, 191 पावर ऑफ चेयरपर्सन, 192 मीटिंग्स ऑफ बोर्ड।
189
हाँ सर 189।
189
हो गया
189
सर।
तो हो गया ना हमारा। हाँ,
हाँ सर,
अब
उसके बाद 190 सर। हाँ
हाँ
सर,
90 करते हैं।
रिमूवल ऑफ मेंबर फ्रॉम ऑफिस पढ़ू
हाँ,
सर। द
एक
सेंट्रल गवर्नमेंट में रिमूव अ मेंबर फ्रॉम ऑफिस
एक
इफ
मिनट,
ही
एक मिनट, मैं पढ़ देता हूँ, मैं पढ़ देता हूँ सर। ये बोलता है
वन, ऐसा हो तो सर मैं पढ़ू सर।
190। हाँ
हाँ
जी, नहीं नहीं, मैं पढ़ता हूँ।
हाँ सर, ठीक है सर, पढ़ो प्लीज सर।
रिमूवल ऑफ मेंबर फ्रॉम ऑफिस। The central government may remove a member from office if he is an undischarged bankrupt, if he has become physically or mentally incapable, if he has been convicted of an offense which in the opinion of the central government involves moral turpitude, has so abused his position as to render his continuation in office detrimental to public interest, provided that no member shall be removed under clause D unless he has been given a reasonable opportunity of being heard in the matter. So in case of D, in case abuse of position is alleged, so in that case he shall be given a reasonable opportunity of being heard. But in case of other A, B and C, central government may remove a member from office. Now 191. 191 talks of powers of the chairperson. Save as otherwise determined by regulations, the chairperson shall have powers of general superintendence and direction of affairs of the board and may also exercise such other powers as may be delegated to him by the board. ठीक है, अब यहां पर आ जाता है रिमूवल ऑफ चेयरपर्सन, कि चेयरपर्सन का रिमूवल कैसे होगा। भाई सेंट्रल गवर्नमेंट क्या करती है, सेंट्रल गवर्नमेंट एक नोटिफिकेशन इशू करती है फॉर अप्रूवल ऑफ दिस फॉर
Chair
अपॉइंटमेंट ऑफ
person.
द चेयरपर्सन, तो
हाँ
उसकी रिमूवल के लिए भी नोटिफिकेशन इशू होगा।
सर, और अपॉइंटमेंट ऑफ चीफ जस्टिस कैसे करना है सर? इट विल बी पासिंग बोथ द हाउस ऑफ पार्लियामेंट सर।
उसको यहाँ ना लाए, वो देखो वो कॉन्स्टिट्यूशन से रिलेटेड है ना, अभी तो हम ये वाला पढ़ रहे हैं ना, इसको कर जब
ठीक है
जब
सर,
उसको
सॉरी
करें
सर।
ना फिर ऐसे उसका कोई यहाँ रेलेवेंस नहीं है ना,
नो वरी सर, सॉरी
है
सर।
ना। हाँ, ना हो
नहीं
190,
सर, थोड़ा इन
नहीं
लाइटर
कोई
वे
बात,
सर।
कोई बात नहीं। 192 बोलता है मीटिंग्स ऑफ द बोर्ड, इसको आज कर लेंगे। मीटिंग्स ऑफ द बोर्ड शेल मीट एट सच, इसके रेगुलेशंस कर लेंगे। द बोर्ड शेल मीट एट सच टाइम्स एंड प्लेसेस एंड ऑब्जर्व सच रूल्स ऑफ प्रोसीजर in regard to transactions of the business at its meeting, including quorums at such meetings, as may be determined by regulations। तो गवर्निंग बोर्ड मीटिंग के रेगुलेशंस है, ठीक है। द चेयरपर्सन, or if for any reason chairperson is unable to attend any meetings of the board, any other member chosen by the members present at the meeting shall preside at the meeting, and all questions which come up before any meeting of the board shall be decided by a majority vote of the members present and voting। ये इंपॉर्टेंट है, ठीक है। तो डिसीजंस कैसे होगा रिगार्डिंग मीटिंग्स ऑफ द बोर्ड? majority vote of the, एक तो सिंपल मेजोरिटी लिखा, मेजोरिटी मतलब सिंपल मेजोरिटी, majority votes of the members present and voting, and in the event of an equality of votes the chairperson or in his absence the person presiding shall have a second or casting, ठीक है। उसके बाद में मीटिंग्स ऑफ द बोर्ड एक बार देख लेते हैं। मीटिंग्स ऑफ द बोर्ड में है आपका
3 to 18।
531, एक मिनट मैं जो नंबर लिख लेता हूँ इसको। 531 स्लाइड है ना, बाद में भूल जाता कहीं। अब गवर्निंग बोर्ड मीटिंग, ये गवर्निंग बोर्ड मीटिंग रेगुलेशंस, एक बार इसको देख लेते हैं। गवर्निंग बोर्ड मीटिंग रेगुलेशंस में क्या बोलता है? गवर्निंग बोर्ड बिजनेस, गवर्निंग बोर्ड क्या करेगा? देखिए दो, एक तो है बोर्ड आपका, बोर्ड मतलब आईबीबीआई, और एक है गवर्निंग बोर्ड। गवर्निंग बोर्ड अलग है, ठीक है। तो गवर्निंग बोर्ड शेल ट्रांसैक्ट द फॉलोइंग बिजनेसेस, regulations to be made under section 240, annual accounts and audit under section 223, annual budget under section 228, annual report under section 229, delegation of powers under section 230, operations manual for various activities। ये सारे गवर्निंग बोर्ड का बिजनेस है। उसके बाद टाइमलाइंस फॉर डिस्पोजल ऑफ वेरियस एक्टिविटीज, एक्सपेंडिचर अबाउट 5 crores, location of office premises, number and categories of employees and their compensation, accommodation for chairperson and whole time members, any other as may be specifically required, any other as may be brought before the governing board, any other as may be required under the law, ठीक है। The business shall be transacted as far as possible in meetings of the governing board, provided that a member may attend a meeting through video conferencing, provided further that wherever considered necessary, a business may be transacted by a resolution passed by circulation of an agenda to the members, provided further that a resolution passed through circulation of the agenda to the members shall be placed before the next meeting of the governing board for ratification, ठीक है। मीटिंग्स कितनी होनी है? At least 4 meetings of the governing board in a year and at least 1 meeting in each quarter. The chairperson or in his absence, any other member nominated by the chairperson in this behalf may convene the meetings of the governing board. Any 3 members may require the chairperson to convene a meeting of the governing board at any time, and the chairperson shall convene the meeting of the governing board accordingly. Provided that if chairperson is not available, any 3 members may require the secretary to convene the meeting of the governing board. And secretary is the employee. Secretary कौन है? Secretary का भी definition दे रखा है यहाँ पर। Secretary means secretary to the governing board designated under regulation 9(1) of these regulations. तो regulation 9(1) देख लेते हैं। The chairperson shall nominate a senior officer of the board as secretary to the governing board to keep custody of common seal, register of attendance of the meetings, agenda, minutes, books, etc. ठीक है। तो secretary कौन है? बेसिकली senior officer of the board। ये हो गया। The meetings of the governing board shall be held at such times and places in India as may be specified in the notice convening the meeting. meetings of the governing board shall ordinarily be held at its head office, provided that the governing board may also hold meeting at its other offices or at any other place in India whenever in the opinion of the governing board it is expedient to do so. The chairperson, or if he is unable to attend the meetings of the governing board for any reason, any other member chosen by the member present at the meeting shall preside over the meeting. ठीक है. नोटिस कितना देना है? Not less than 10 days notice shall ordinarily be given. ठीक है. कुछ मेन पॉइंट्स आप नोट कर सकते हैं, जो आपको पता है कहां से सवाल पूछ सकता है. भाई 2-3 नंबर का सवाल कहीं ना कहीं से आ सकता है, जितने भी रेगुलेशंस हम पार्ट 4 और पार्ट 5 में पढ़ेंगे. मैक्सिमम 5 नंबर लगा लो, 5 का भी नहीं पूछता, 2 या 3 नंबर का पूछेगा इसमें से. अब वो सिलेबस है बहुत वास्ट, इसमें कहीं से भी पूछ सकता है. तो इतना तो कम से कम ध्यान रखना है, जहां पर अमाउंट्स है, जहां पर डेज है ना, जहां पर रेट ऑफ इंटरेस्ट है, पेनल्टी है, पेड अप कैपिटल है, टर्नओवर है, इतना तो कम से कम आप ध्यान में रखिए. नोटिस बोलता है नॉट लेस देन 10 days notice shall ordinarily be given for each meeting of the governing board, and such notice along with the agenda shall be sent to every member at his usual address in India or by email as furnished by him to the board, provided that if an urgent meeting of the governing board is required to be convened, 10 days notice may be dispensed with by the chairperson. ठीक है. And no business other than that for which the meeting has been convened shall be transacted at a meeting of the governing board except with the permission of the chairperson. Quorum कितना है? Quorum भी important है. 5 members if the governing board has 8 or more members, and 3 members if the governing board has less than 8 members. Quorum पे भी सवाल पूछ सकता है. ठीक है. तो 5 members if the governing board has 8 or more members, and 3 members if the governing board has less than 8 members shall constitute the quorum for the transaction of business at a meeting of the governing board. And all business which come up before any meeting of the governing board shall be decided by a majority vote of the members present and voting, and in the event of inequality of votes, the chairperson or in his absence the member presiding shall have a second or custom. Leave of absence. The governing board may grant leave of absence to a member not present in the meeting, and such leave of absence shall be recorded in the minutes of the meeting. Minutes of the meeting. The board shall cause the minutes of all the proceedings to be maintained in the books kept for the purpose, which may be in the form of binders containing loose leaves duly numbered. A copy of draft minutes of the proceedings of each meeting of the governing board shall be circulated as soon as possible for confirmation by the members. The confirmed minutes shall be signed by the chairperson or the member presiding at the succeeding meeting and taken on record thereafter. सेक्रेटरी का पहले ही पढ़ लिया हमने. द चेयरपर्सन शेल नॉमिनेट ए, कौन नॉमिनेट कर रहा है इसको? चेयरपर्सन. द चेयरपर्सन शेल नॉमिनेट ए सीनियर ऑफिसर ऑफ द बोर्ड एज सेक्रेटरी टू द गवर्निंग बोर्ड टू कीप कस्टडी ऑफ कॉमन सील, रजिस्टर ऑफ अटेंडेंस ऑफ द मीटिंग्स, एजेंडा, मिनट्स बुक एंड अदर डॉक्यूमेंट्स, records etc. pertaining to the meetings of the governing board and of the committees thereof. The secretary shall arrange meetings, record minutes, and generally ensure that these regulations are followed. Charter of conduct. Member not to participate in meetings in certain cases. ठीक है. तो किन केसेस में पार्टिसिपेट नहीं करेगा? If he is interested naturally, है ना. Every member who is directly or indirectly concerned or interested in any business coming up for consideration. ठीक है. He will disclose the nature of his interest at such meeting, and such disclosure shall be recorded in the proceedings of the governing board, and the member shall not take part in any deliberation or decision of the governing board with respect to that business. Explanation. The expression directly or indirectly referred to in this regulation shall include any concern or interest of a member either by himself or through his relatives within the meaning of the definition of section 2 subsection 77 of the Companies Act, or by reason of being a partner or director of that concern. अब सेक्शन 2 सबसेक्शन 77 में क्या कहता है? अगर हम सेक्शन 2 सबसेक्शन 77 देखें तो ये बात बोलता है लिस्ट ऑफ रिलेटिव्स. यहां पर लिस्ट ऑफ रिलेटिव्स दे रखी है. इसमें है फादर, मदर, सन, सन्स वाइफ, डॉटर, डॉटर्स हस्बैंड, ब्रदर और सिस्टर। ठीक है, ये 8 रिलेशंस दे रखे हैं। स्पेसिफिकेशन ऑफ डेफिनेशंस 277 relative with reference to any person means anyone who is related to another if they are members of HUF, if they are husband and wife, and one is related to another in the following manner. तो 8 relatives दे रखे हैं आपकी लिस्ट। ठीक है, ये section 2 subsection 77. Now obligations of a member to give information of disqualification. A member shall as soon as possible inform the board if he becomes subject to any of the disqualifications specified in section 190 of the code. The board shall inform the central government if it comes to the notice of the board that any member has attracted any of the disqualifications referred to in sub-regulation 1. Declaration of fidelity. ठीक है, then manner and forms in which contracts may be executed. खास important है. Affixation meetings of the committee. अब ये मीटिंग्स ऑफ कमेटी पर आ गया, समझ लो। पहले मीटिंग्स ऑफ बोर्ड थी, गवर्निंग बोर्ड। अब है कि सब्जेक्ट टू सब रेगुलेशन 2 these regulations shall apply mutatis mutandis to the meetings of the committee of these committees बना देंगे ना गवर्निंग बोर्ड वाले। तो 50% of the members of the existing strength of the committee shall constitute quorum for meetings of the committee। ये हमारा हो गया पूरा, इसमें कोई खास बात नहीं है। एक्सेप्टेंस ऑफ गिफ्ट्स, ये इंपॉर्टेंट है, इसके ऊपर कई बार सवाल पूछ लेता है। ये कहता है ए होल टाइम मेंबर shall not accept any gift by whatever name called to the extent possible from a regulated entity. A whole time member shall hand over the gift if he receives any and the value exceeds rupees 5,000 to the IB। ठीक है, तो इस वैल्यू पे सवाल कई बार पूछ लेता है। बस इतना ही है। अब हम चलते हैं दोबारा अपना हम यहाँ पर थे 192 पर। ठीक है, अब हमने करना है 193। 193 क्या बोलता है? मेंबर्स नॉट टू पार्टिसिपेट इन मीटिंग्स इन सर्टेन केसेस। Any member who is a director of a company and who as such director has any direct or indirect pecuniary interest in any matter coming up for consideration at a meeting of the board shall as soon as possible after relevant circumstances have come to his knowledge disclose the nature of his interest at such meeting, and such disclosure shall be recorded in the proceedings of the board, and the member shall not take part in any deliberation or decision of the board with respect to that matter। ठीक है, नाउ सेक्शन 194। सेक्शन 194 बोलता है वैकेंसीज एटसेट्रा नॉट टू इनवैलिडेट प्रोसीडिंग्स ऑफ बोर्ड एंड ऑफिसर्स एंड एम्प्लॉयज ऑफ द बोर्ड। ठीक है, अच्छा, बोर्ड में जो एम्प्लॉयज के लिए है आपके एंगेजमेंट ऑफ रिसर्च एसोसिएट्स, ये आपके रेगुलेशंस। द सैलरीज एंड अलाउंसेस पेएबल टू एंड अदर टर्म्स एंड कंडीशंस ऑफ सर्विस ऑफ ऑफिसर्स एंड एम्प्लॉयज। तो 3 तरह के रेगुलेशंस हैं। एक तो चेयरमैन एंड गवर्निंग मेंबर्स ऑफ द बोर्ड के रेगुलेशंस है, एक फिर एंगेजमेंट ऑफ रिसर्च एसोसिएट्स के रेगुलेशंस है, और फिर एम्प्लॉयज सर्विस रेगुलेशंस। ठीक है, तो एम्प्लॉयज सर्विस रेगुलेशंस थोड़े से देख लेते हैं। उसमें 1-2 पॉइंट जो जिस पर सवाल पूछ लेता है। अगर और कुछ नहीं भी याद रखना तो कम से कम गिफ्ट का वाला पॉइंट इसमें जरूर आप ध्यान रख लीजिए। एक्सेप्टेंस ऑफ गिफ्ट, ये वाला पॉइंट जरूर पढ़ लीजिएगा। इसका रेगुलेशन नंबर 45 एम्प्लॉय सर्विस रेगुलेशंस क्या बोलता है? एन एम्प्लॉय शैल नॉट सॉलिसिट और एक्सेप्ट एनी गिफ्ट or permit any member of his family or any person acting in his behalf to accept any gift from any person with whom the employee is likely to have official dealings, either directly or indirectly from any subordinate employee. Trivial gifts like small packet of sweets, diaries, calendars on the occasion of Diwali and New Year, or a casual meal, lift, or other social hospitality may, however, be accepted. The expression gift shall include free transport, boarding, lodging, or other service, or any other pecuniary advantage, unless it is provided by a near relative or a personal friend having no official dealings with the employee or with the board. On occasions such as marriage, anniversaries, funerals, or religious functions, when the making of gifts is in conformity with the prevailing religious or social practice, an employee may accept gifts from his personal friends having no official dealings with the employee or with the board, but he shall report to the board within 30 days if the value of any of such gifts exceeds ₹10,000. ठीक है, तो ये गिफ्ट वाला पॉइंट आपको जरूर ध्यान में रखना। अपील आपको करनी है एपीलेट अथॉरिटी
45 days. 45 days, sir.
अब एपीलेट अथॉरिटी का डेफिनेशन दे रखा है क्या, वो देख लेते हैं। कॉम्पिटेंट अथॉरिटी, एपीलेट अथॉरिटी। आपको अपील एपीलेट अथॉरिटी करना है तो एपीलेट अथॉरिटी का मीनिंग पता होना चाहिए। एपीलेट अथॉरिटी क्या है, ये है एपीलेट अथॉरिटी बोर्ड वेयर द चेयरपर्सन इज द कॉम्पिटेंट अथॉरिटी, चेयरपर्सन वेयर द होल टाइम मेंबर इज द कॉम्पिटेंट अथॉरिटी, है ना, होल टाइम मेंबर वेयर एग्जीक्यूटिव डायरेक्टर इज द कॉम्पिटेंट अथॉरिटी एंड एग्जीक्यूटिव डायरेक्टर वेयर चीफ जनरल मैनेजर ह्यूमन रिसोर्सेज इज द कॉम्पिटेंट अथॉरिटी। तो एपीलेट अथॉरिटी मतलब एक लेवल ऊपर है उससे। ठीक, चलिए ये भी हो गया। अब हम थोड़ा सा दोबारा वहीं चलते हैं। यहाँ पर थे हम लोग, ये 193 हो गया था हमारा, 194 हो गया, 195। 195 बोलता है पावर टू डेजिग्नेट फाइनेंशियल सेक्टर रेगुलेटर until the board is established. The central government may by notification designate any financial sector regulator to exercise the powers and functions of the board. कोई खास बात नहीं। 195 हो गया। Now 196। 196 में पावर्स ऑफ द बोर्ड दे रखी है, पावर्स एंड फंक्शंस ऑफ द बोर्ड। ठीक है, तो ये जनरल टाइप की पावर्स है, इसको एक बार देख लीजिएगा आप इसमें क्या है। 196 हो गया। 197 है कॉन्स्टिट्यूशन ऑफ एडवाइजरी कमेटी, एग्जीक्यूटिव कमेटी एंड अदर कमिटीज। तो ये अलग अलग टाइप की इसमें कमिटीज। एडवाइजरी कमेटी के फिर रेगुलेशंस है। ठीक है, एडवाइजरी कमेटी रेगुलेशंस एक बार देख लेते हैं। ये एडवाइजरी कमेटी रेगुलेशंस है। कंपोजिशन, मीटिंग्स, फीस। फीस इसमें मिलेगी, मेंबर ऑफ द कमिटी शैल बी एंटाइल्ड टू ए सिटिंग फीस ऑफ 10,000 फॉर ए मीटिंग ऑफ द कमिटी। ये वाला इंसॉल्वेंसी प्रोफेशनल एजेंसी रेगुलेशंस तो हमने कर ही लिए मोटा मोटा। चलो दोबारा देखते हैं क्वेरीज। देखो सेलेक्टिव स्टडी में ना बहुत ज्यादा इस पे स्ट्रेस देने की जरूरत नहीं है। वो चार्ट कर लीजिए और इसमें जो जो मोटा मोटा मैंने बताया गिफ्ट्स वगैरह का या सैलरीज का, उतना कम से कम आप याद जरूर रख लीजिए। बाकी पूछने को तो वो कहीं से भी पूछ लेगा, उसकी कोई लिमिट ही नहीं है। ये 196 हो गया, 197, 197 एडवाइजरी कमेटी हो गया, 198। 198 बात करता है कंडोनेशन ऑफ डिले। ठीक है, तो अगर बोर्ड डज नॉट परफॉर्म एनी एक्ट विद इन द पीरियड स्पेसिफाइड, द रिलेवेंट एडजुडिकेटिंग अथॉरिटी मे फॉर रीजंस टू बी रिकॉर्डेड इन राइटिंग कंडोन द डिले। ये 198 है। एम्प्लॉय सर्विस रेगुलेशंस हमने देख लिए। ग्रीवांस एंड कंप्लेंट हैंडलिंग मोटा मोटा हमने देख लिया। इसमें क्या है, एग्रीव्ड कौन है? Aggrieved means a stakeholder who has filed a grievance with the board on failing to get his grievance redressed. और complaint क्या है? Complaint means a written expression by a stakeholder alleging contravention of any provision of the code. Filing of grievance, ये थोड़ा सा डिटेल में पढ़ लेते हैं। मोटा मोटा तो हमने देख लिया फाइलिंग ऑफ ग्रीवांस का, लेकिन थोड़ा देख लेते हैं। A stakeholder who wishes to file a grievance shall file it with the board. Grievance shall state the identity, details of the identity of the aggrieved, details of the identity of the service provider, details of the conduct of the service provider that has caused the suffering. ठीक है, क्योंकि ग्रीवेंस में आपको सफरिंग भी बतानी है, कंप्लेंट में सफरिंग नहीं बतानी। ठीक है ना। Details of the suffering, whether pecuniary or otherwise, the aggrieved has undergone, how the conduct of the service provider has caused the suffering of the aggrieved, details of his efforts to get the grievance registered from redress from the service provider, and why the response, if any, of the service provider is not satisfactory. तो पहले आपको सर्विस प्रोवाइडर को अप्रोच करना है, उसके बाद में अगर वो नहीं होगा तब बोर्ड को आपको ग्रीवेंस या कंप्लेंट फाइल करनी है। ठीक है। A stakeholder who wishes to file a complaint shall file it at the board in Form A along with the demand draft for 2,500 rupees. ठीक है, और within 45 days of the occurrence of the cause of action. And if there is sufficient delay, then 30 days, another 30 days. और कैसे फाइल करना है? On the dedicated portal. Identity of the stakeholder, ये इंपॉर्टेंट है। A stakeholder filing a grievance or a complaint shall disclose, उसको तो अपनी आइडेंटिटी डिस्क्लोज करनी ही करनी है। ठीक है ना। इन द ग्रीवेंस और कंप्लेंट एज द केस में बी, एंड ऑल्सो द आइडेंटिटी ऑफ द ऑथराइज्ड रिप्रेजेंटेटिव हु इज ऑथराइज्ड टू फाइल इट। A stakeholder filing grievance or a complaint as the case may be may request the board to keep the identity confidential, and in that case the board shall keep it confidential unless its disclosure is necessary for processing the grievance or complaint under any law. ठीक है। अच्छा, अगर एक से ज्यादा ग्रीवेंस या कंप्लेंट आ गई तो उनको क्लब कर देंगे। ठीक है। डिस्पोजल, द बोर्ड में सीक एडिशनल इंफॉर्मेशन एंड रिकॉर्ड्स फ्रॉम द एग्रीव्ड एंड फ्रॉम द सर्विस प्रोवाइडर। ठीक है, और कितने दिन में वो दे देंगे सबमिट? ये 7 डेज के अंदर। प्रोवाइड दैट एन एडिशनल टाइम नॉट एक्सीडिंग 7 डेज में बी ग्रांटेड, और बोर्ड को क्लोज करना है ग्रीवेंस को विद इन 30 डेज। ठीक है, इफ इट डज नॉट रिक्वायर एनी रिड्रेस। ठीक, the board shall direct the service provider to redress the grievance within 30 days of its receipt if it requires any redress. Disposal of grievance by insolvency professional agency. ठीक, notwithstanding anything contained in regulation 6, the board may forward a grievance against an insolvency professional फॉर डिस्पोजल बाय द IPA ऑफ विच इज मेंबर। ठीक है, तो वो फिर डिस्पोज ऑफ करेंगे विद इन 30 days। कंप्लेंट, डिस्पोजल ऑफ कंप्लेंट, दोनों से इंफॉर्मेशन मांग सकते हैं, 7 days के अंदर देंगे, एडिशनल टाइम दे सकते हैं 7 days का, 30 days के अंदर आप इसको कंप्लेंट को क्लोज कर दो। ठीक है, रिव्यू भी हो सकता है विद इन 30 days, एंड बोर्ड शेल डिस्पोज ऑफ द रिव्यू विद इन 30 days। ये मोटा मोटा हमने चार्ट में भी कवर किया हुआ है। अच्छा, और अगर बोर्ड को लगता है कि भैया कुछ वाकई गड़बड़ हुई है, तो फिर वो क्या करेगा, इंस्पेक्शन एंड इन्वेस्टिगेशन रेगुलेशंस में इन्वेस्टिगेशन ऑर्डर कर देगा। And where the board is of the opinion that the complaint is not frivolous, it shall refund the fees of 2,500 rupees received under sub-regulation 3। ठीक है, ये फॉर्म ए है आपका। ये डिटेल्स, इंस्पेक्शन एंड इन्वेस्टिगेशन रेगुलेशंस। डिसिप्लिनरी कमेटी, इस थोड़ा सा इंस्पेक्शन एंड इन्वेस्टिगेशन रेगुलेशंस भी देख लेते हैं 5 मिनट। एक तो यहाँ डेफिनेशन है एसोसिएटेड पर्सन की। तो एसोसिएटेड पर्सन मीन्स ए प्रोप्राइटर, पार्टनर, डायरेक्टर, ऑफिसर और एन एम्प्लॉय ऑफ ए सर्विस प्रोवाइडर। ठीक है ना, तो इंफॉर्मेशन इनसे भी मांग सकते हैं, एसोसिएटेड पर्सन से भी, और एनी अदर पर्सन एक्टिंग फॉर और ऑन बिहाफ ऑफ ए सर्विस प्रोवाइडर अंडर इंस्पेक्शन और इन्वेस्टिगेशन। डिसिप्लिनरी कमेटी, डिसिप्लिनरी कमेटी मीन्स ए कमेटी ऑफ होल टाइम मेंबर और मेंबर्स कॉन्स्टिट्यूटेड बाय द बोर्ड। ठीक है, मतलब एक मेंबर भी हो सकता है, provided that the whole time members in the disciplinary committee shall not be associated with the investigation or inspection। ठीक है, मतलब जो इंस्पेक्टिंग अथॉरिटी बनेगी उसमें ये वाले लोग नहीं आएंगे जो डिसिप्लिनरी कमेटी में मेंबर है। इट इज hereby clarified that associated shall mean involvement in the conduct of investigation or inspection or consideration of the investigation or inspection report or issuance of a show cause। इन्वेस्टिगेटिंग अथॉरिटी, इन्वेस्टिगेटिंग ऑफिसर अथॉरिटी में कौन आएंगे, ऑफिसर और टीम ऑफ ऑफिसर्स ऑफ द। ठीक है, इंस्पेक्शन बाय द बोर्ड, द बोर्ड शैल कंडक्ट इंस्पेक्शन ऑफ सच नंबर ऑफ सर्विस प्रोवाइडर्स एवरी ईयर एज में बी डिसाइडेड बाय द बोर्ड फ्रॉम टाइम टू टाइम। जरूरी नहीं कि कोई कंप्लेंट आए तो भी इंस्पेक्शन होगा। ठीक है, उन्होंने कुछ इंस्पेक्शन तो करना ही है अपना। Without prejudice to the provisions of sub-regulation 1, the board may conduct inspection of a service provider under section 218. The board may, for the purpose of this regulation, by an order, direct an inspecting authority to conduct an inspection of record of a service provider for purposes specified under sub-regulation 4। Purposes क्या हुआ, ये purposes, records are being maintained by a service provider, adequate internal control procedures are there, circumstances which would render a service provider ineligible or unfit। ठीक है, abidance by the code rules regulations, inquire into complaints। तो जो ऑर्डर होगा इसमें रेफर टू इन सब रेगुलेशन 1 है, जो इंस्पेक्शन का ऑर्डर होगा उसमें क्या स्पेसिफाई करेंगे, स्कोप ऑफ इंस्पेक्शन, कंपोजिशन ऑफ इंस्पेक्टिंग अथॉरिटी। तो इंस्पेक्टिंग अथॉरिटी में कौन आ रहे हैं, ऑफिसर्स आ रहे हैं, एम्प्लॉइज आ रहे हैं बेसिकली, है ना। इंस्पेक्टिंग अथॉरिटी, ऑफिसर और टीम ऑफ ऑफिसर्स ऑफ द बोर्ड which has been directed by the board to conduct the inspection। कंडक्ट ऑफ इंस्पेक्शन में एटलीस्ट 10 days नोटिस। ठीक है, बट द सेम में बी डिस्पेंस्ड विद। ये चार्ट में ब्रीफली हमने कवर किया हुआ है। The inspecting authority may require the service provider or an associated person to submit records as may be required before commencement of the inspection। The inspecting authority may visit the offices of the service provider for conducting the on-site inspection। Interim inspection report, the inspecting authority may submit an interim inspection report to the board if it considers appropriate, keeping in view the nature and progress of investigation। The inspecting authority shall submit an interim inspection report if required। बोर्ड बोलेगा तो सबमिट करनी है, और बाकी अगर बोर्ड ने नहीं बोला तो कर सकती है अगर उनको लगता है। इफ द बोर्ड इज सेटिस्फाइड फ्रॉम द इंटरिम इंस्पेक्शन रिपोर्ट दैट देयर इज ग्रॉस वायोलेशन, तो वो फिर क्या करेगा? तो सेक्शन 220 सबसेक्शन 2, द बोर्ड शैल रेफर द मैटर टू डिसिप्लिनरी कमेटी फॉर एन अप्रोप्रिएट एक्शन। ठीक है। The interim order referred to in sub-regulation 4 shall lapse on expiry of 90 days. Inspection report. फिर draft inspection report. The inspecting authority shall send a copy of the draft inspection report to the service provider, requiring comments of the service provider within 15 days from the receipt of the draft inspection report. The inspecting authority shall submit a copy of the draft inspection report to the board. तो board को भी दे रहे हैं और service provider को भी दे रहे हैं. The board shall examine the draft inspection report as to whether inspection is complete and satisfactory or requires further inspection and advise the inspecting authority accordingly within 15 days of the receipt of the draft inspection report. उसके बाद अगला है फिर इन्वेस्टिगेशन। इन्वेस्टिगेशन के लिए इन्वेस्टिगेटिंग अथॉरिटी है, वही 10 days का नोटिस देंगे, इट मे बी डिस्पेंस्ड विद ऑल्सो। और इसमें ड्राफ्ट इन्वेस्टिगेशन रिपोर्ट आपको शेयर नहीं करनी है सर्विस प्रोवाइडर से। शो कॉज नोटिस। अब मेरा ख्याल जो बाकी वाला काम बच गया ना वो नेक्स्ट क्लास में कर लेंगे, है ना। ये हमारा सेक्शन 199, सेक्शन 199 ऑनवर्ड्स नेक्स्ट क्लास में करते हैं।